The Subcommittee on the Constitution and Civil Justice will come to order without objection. The Chair is authorized to declare recesses of the committee at any time. Good morning. Currently, Rule 11 of the Federal Rules of Civil Procedure sets out one of the most basic requirements for litigation in federal court, that papers filed with a federal district court must be based on both the facts and the law. That is to say, any time a litigant signs a filing in federal court, they are certifying that to the, quote, best of the person's knowledge, information, and belief, the filing is accurate, based on the law or reasonable interpretation of the law, and is brought for a legitimate purpose. Now, this is a simple requirement, one that both sides to a lawsuit must abide by if we are to properly have a functional federal court system. However, under the current federal procedural rules, there is no requirement that a failure to comply with Rule 11 results in sanctions for the party that filed that frivolous lawsuit. The fact that litigants can violate Rule 11 without penalty significantly reduces the deterrent effect of Rule 11. This harms the integrity of the federal courts and forces both plaintiffs and defendants to spend money to respond to frivolous claims and arguments with no guarantee of compensation when the claims against them are found frivolous by a federal judge. The Lawsuit Abuse Reduction Act corrects this flaw by requiring that federal district court judges impose sanctions when Rule 11 is violated. It will relieve litigants from the financial burden of having to respond to frivolous claims by requiring those who violate Rule 11 to reimburse the opposing party reasonable expenses incurred as a direct result of the violation. Furthermore, the legislation eliminates Rule 11's 21-day safe harbor provision, which currently gives litigants a free pass to make frivolous claims so long as they withdraw those claims if the opposing side objects within 21 days. As Justice Scalia correctly pointed out when Rule 11 was gutted in 1993, quote, those who file frivolous suits and pleadings should have no safe harbor. Parties will be able to file thoughtless, reckless, and harassing pleadings, secure in the knowledge that they have nothing to lose. If objection is raised, they can retreat without penalty, unquote. Now, although this legislation makes changes to Rule 11, it is important to recognize that nothing in this legislation changes the standard by which courts determine whether a pleading or a filing violates Rule 11. Courts will apply the same legal standard they currently apply to determine if a filing is frivolous under the rule. So in the end, all this legislation really does is make the technical and conforming changes to Rule 11 necessary to make sanctions mandatory rather than discretionary. Victims of frivolous lawsuits are just as deserving of compensation as any other victim, and there is no reason those who are the victims of frivolous lawsuits in federal court should be the only litigants to go without compensation when they prove their injuries in court. According to the Federal Rules of Civil Procedure, the goal of the rules is to ensure that every action and proceeding in federal court be determined in a, quote, just, speedy, and inexpensive, quote, unquote, manner. That goal is best served through mandatory sanctions for violating the simple requirements of Rule 11, that every filing be based on both the law and the facts. And finally, this bill has been introduced in the House and Senate in previous Congresses. This Congress is different. For the first time, this bill has been introduced in the Senate by the chairman of the Senate Judiciary Committee himself, Senator Charles Grassley, who is a leading advocate for the rights of victims, including the victims of frivolous lawsuits. And with that, I look forward to hearing from all of our witnesses today, and I would now recognize the ranking member of the subcommittee, Mr. Cohen from Tennessee, for his opening statement.
Thank you, Mr. Chair. Today we consider H.R. 758, titled the Lawsuit Abuse Reduction Act of 2015. It is substantially identical to bills we considered in the 112th and 113th Congresses, and we've considered even earlier versions of this bill going back at least a decade. Given this fact, I have this Bill Murray-like feeling. Been here before in Groundhog's Day. H.R. 758, like its predecessors, is a solution in search of a problem that would threaten to do more harm than good if enacted. H.R. 758 would restore the 1983 version of Rule 11 of the Federal Rules of Civil Procedure by making sanctions for Rule 11 mandatory and eliminating the current safe harbor provision that allows a party to withdraw or correct any allegedly offending submission to the court within 21 days after service of such submission. The safe harbor is important. The chair in his opening remarks said it just guarantees and people that have recourse. Well, they have recourse, but it's up to the judge's determination, and that's important that the judge have that discretion, I think. Moreover, the bill would go beyond the 1983 rule by requiring the court to award these reasonable attorneys' fees and costs. And I'm all in favor of Rule 11 and sanctioning attorneys that violate such with frivolous lawsuits. But right now they are discretionary in the court's discretion, and we have judges for a reason, and they have more intimate knowledge of the facts and the circumstances and the attorneys involved and the safe harbor option. No empirical evidence suggests there's a need really to change Rule 11. In fact, there were good reasons why the Judicial Conference of the United States amended the 83 rule of Rule 11, and for these same reasons, H.R. 758 is ill-advised. The 83 rule caused excessive litigation. Many civil cases had a parallel track of litigation referred to as satellite litigation over Rule 11 violations because having mandatory sanctions and no safe harbor provisions caused parties on both sides to litigate the Rule 11 matter to the bitter end. So courts become more bloated and crowded dockets. The dramatic increase in litigation spawned by the 83 rule not only resulted in delays in resolving the underlying case and increased costs for the litigants, but also restrained our judicial resources. It is clear H.R. 758 will result in more, not less, litigation and impose a greater burden on the judiciary. Ultimately, the type of Rule 11 sanctions regime that H.R. 758 envisions will only favor those with the money and resources to fight expensive and drawn-out litigation battles. H.R. 758 also threatens judicial independence by removing that discretion the judges presently have when determining whether or not to impose sanctions. It circumvents the painstakingly thorough Rules Enabling Act process. We're recklessly attempting to amend the rules directly, even over the Judicial Conference's objections. And I'd like each of our witnesses to tell me a precedent where, rather than our process being that the courts recommend and propose rules and we approve or disapprove, where we in the Congress have in the past changed the rules by legislation without the courts submitting rules. I mean, it's definitely a deviation in the process of the judiciary making the rules, but the check and balance of the legislature approving or disapproving, and we can disapprove a rule or recommend, but I believe it's extremely rare, and I look forward to our experts telling me where the legislature have specifically made a law that changed a rule without the judiciary coming forth on that. We know 1983 rules had a disproportionately chilling impact on civil rights cases, and that is most concerning to me and to others. And there's no reason to think H.R. 758 will not have such a similar chilling effect. We just came through the reenactment of the Selma March. We've seen so many failures in our legislative and political system to where we haven't moved forward on civil rights, we've moved backwards. And what happened in Selma, we need to see that we have vigorous enforcement of civil rights and voting rights. And this could be a chilling effect on civil rights cases that depend sometimes on novel arguments for the extension, modification, or reversal of existing laws, but have brought us into the 21st century. Not surprisingly, a federal judicial center found that the incidence of Rule 11 motions was higher in civil rights cases than other type of cases when the 1983 rule was in place, notwithstanding the fact that the 1983 rule was neutral on its face. Even a landmark case like Brown versus Board of Education arguably may have been delayed or may not have been pursued to its conclusion had our H.R. 758 changes to Rule 11 been in effect at the time. Certainly the legal arguments in that case were novel and not based on existing law. At a minimum, defendants could have used Rule 11 as amended by H.R. 758 as a weapon to dissuade the plaintiffs or weaken their resolve. The Judicial Conference of the United States, the policy-making arm of the federal judiciary, opposed legislation substantially identical to H.R. 758 last conference. Similarly, the American Bar Association in the past. Coalition of groups concerned about justice, the Alliance for Justice, the Consumer Federation of America, the National Consumer Law Center, and the National Employment Lawyers previously opposed the measure. I ask unanimous consent to that a letter in opposition sent to the subcommittee by a public citizen dated March 16 be submitted into the record, and I appreciate that. Without objection, H.R. 758 takes away judicial discretion, which is so needed and will result in more litigation rather than less. I urge my colleagues to oppose and yield back the balance of my non-existent balance of time.
And I thank the gentleman, and I now yield to the chairman of the committee, Mr. Goodlatte from Virginia.
Well, thank you, Mr. Chairman. H.R. 758, the Lawsuit Abuse Reduction Act, would restore mandatory sanctions for frivolous lawsuits filed in federal court. Many Americans may not realize it, but today, under what is called Rule 11 of the Federal Rules of Civil Procedure, there is no requirement that those who file frivolous lawsuits pay for the unjustified legal costs they impose on their victims, even when those victims prove to a judge the lawsuit was without any basis in law or fact. As a result, the current Rule 11 goes largely unenforced because the victims of frivolous lawsuits have little incentive to pursue additional litigation to have the case declared frivolous when there is no guarantee of compensation at the end of the day. H.R. 758 would finally provide light at the end of the tunnel for the victims of frivolous lawsuits by requiring sanctions against the filers of frivolous lawsuits, sanctions which include paying back victims for the full costs of their reasonable expenses incurred as a direct result of the Rule 11 violation, including attorney's fees. The bill also strikes the current provisions in Rule 11 that allow lawyers to avoid sanctions for making frivolous claims and demands by simply withdrawing them within 21 days. This change eliminates the free pass lawyers now have to file frivolous lawsuits in federal court. The lack of mandatory sanctions leads to the regular filing of lawsuits that are clearly baseless. For example, a man sued a small business owner for violations of federal regulations in a parking lot he doesn't own or lease. A woman had her car repossessed and then filed a $5 million federal lawsuit for the half tank of gas she had left in the car. A high school teacher sued a school district claiming it discriminated against her because she has a phobia, a fear of young children. Her case was dismissed by the Equal Employment Opportunity Commission, but that didn't prevent her from filing a federal lawsuit. These real yet absurd cases have real-life consequences for their victims. But the victims of lawsuit abuse are not just those who are actually sued. Rather, we all suffer under a system in which innocent Americans everywhere live under the constant fear of a potentially bankrupting frivolous lawsuit. As the former chairman of the Home Depot Company has written, an unpredictable legal system casts a shadow over every plan and investment. It is devastating for startups. The cost of even one ill-timed abusive lawsuit can bankrupt a growing company and cost hundreds of thousands of jobs. The prevalence of frivolous lawsuits in America is reflected in the absurd warning labels companies must place on their products to limit their exposure to frivolous claims. A 5-inch brass fishing lure with 3 hooks is labeled harmful if swallowed. In a warning label on a baby stroller, the caution is, remove child before folding. A sticker on a 13-inch wheel on a wheelbarrow warns not intended for highway use. A household iron contains the warning, never iron clothes while they are being worn. And a cardboard car sun shield that keeps sun off the dashboard warns, do not drive with sun shield in place. In his 2011 State of the Union address, President Obama said, quote, I'm willing to look at other ideas to rein in frivolous lawsuits. Mr. President, here it is, a 1-page bill that would significantly reduce the burden of frivolous litigation on innocent Americans. I thank the former chairman of this committee, Lamar Smith, for introducing this simple, common-sense legislation that would do so much to prevent lawsuit abuse and restore Americans' confidence in the legal system. I look forward to hearing the testimony of our witnesses, and I yield back. Thank you, Mr. Chairman.
And I thank the gentleman, and without objection, other members' opening statements will be made part of the record. So let me now introduce our witnesses. Good morning to all of you. Our first witness is Elizabeth Melito, the Senior Executive Counsel with the National Federation of Independent Business Small Business Legal Center. Previously, she has worked for the U.S. Department of Veterans Affairs, where she focused on employment and labor matters. A former editor of notes and comments for the Maryland Law Review and a graduate of the University of Maryland School of Law, Ms. Melito is responsible for managing cases and legal work for the Nfib Small Business Legal Center and working on labor and employment policy. I'm glad to have you here. Our second witness is Robert Peck. President of the Center for Constitutional Litigation. Mr. Peck has taught constitutional law and state constitutional law at the George Washington University Law School and American University Washington College of Law as a member of the adjunct faculty. He is a co-chair of the Lawyers Committee for the National Center for State Courts and a delegate in the American Bar Association's House of Delegates. Welcome, sir. Our third witness is Carrie Silverman, a partner at the Shook, Hardy, and Bacon law firm in Washington, D.C. Mr. Silverman's public policy work focuses on civil justice reform, and he's published over 25 articles in prominent law journals. He is a recipient of the Burton Award for Excellence in Legal Writing and an adjunct professor at the George Washington University Law School, where he earned his J.D. and Master of Public Administration. Welcome, sir. Each of the witnesses' written statements will be entered into the record in its entirety. So I would ask that each of you summarize his or her testimony in 5 minutes or less, and to help you stay within that time, there's a timing light in front of you. The light will switch from green to yellow, indicating that you have 1 minute to conclude your testimony. When the light turns red, it indicates that the witness's 5 minutes have expired. And before I recognize the witness, it is the tradition of the subcommittee that they be sworn, so if you'd please stand to be sworn. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Let the record reflect that the witness is answered in the affirmative. So I would now recognize our first witness, Ms. Melito. And Ms. Melito, if you'll make sure you turn that microphone on before speaking. Yes, ma'am.
Thank you, Mr. Chairman and distinguished subcommittee members, for inviting me to provide testimony regarding the impact lawsuits, and particularly frivolous lawsuits, have on small businesses. While specific stories of lawsuit abuse vary from business to business, there is one reoccurring theme. This country's legal climate hinders economic growth and hurts job creation. Due to this, NFIB's members and small business owners throughout the country are fed up with the inability to pass meaningful legal reform. When it comes to lawsuits and small business, today I wish to highlight 4 things. First, small businesses are easy targets for frivolous lawsuits. Sophisticated attorneys do not sue NFIB members. Instead, small businesses are more likely to be sued by small-time lawyers who threaten cookie-cutter lawsuits that are expected to be settled immediately. One of the most prevalent forms of lawsuit abuse occurs when plaintiffs or their attorneys are merely trolling for cases. A plaintiff or an attorney will travel from business to business looking for violations of a particular law. In such cases, the plaintiff is generally not concerned with correcting the problem as she is with extracting a settlement from the small business owner. In many instances, the plaintiff's attorney will initiate the claim not with a lawsuit, but with a demand letter requesting immediate settlement. In California, attorneys have been known to rake in several $million a year, fleecing small business owners with these sort of schemes. Ann Kinner, who owns Seabreeze Books and Charts in Point Loma, California, is one such small business owner and an NFIB member who has been targeted by frivolous litigation. Kinner's store has been sued twice for ADA violations. She went to court, fought, and won both these lawsuits. But the defense has cost her $10,000, money she could have used, in her words, to pay a new employee for half a year. In Kinner's words, the only people who win in these cases are the lawyers. 2, small businesses settle and avoid going to court. When a conflict arises, small businesses or the insurer on their behalf will likely pay rather than fight a claim, whether there's a meritorious defense or not. Calculating attorneys know that they can extort settlements from small businesses by threatening to sue. Small businesses simply cannot absorb the cost of a legal battle as easily as larger businesses, or for that matter, the cost of paying damages if they should lose in the end. This means that, in many cases, the small business owner may be risking financial ruin if the owner refuses to settle. Since there's no guarantee that at the end of the fight, the defendant will prevail, small business owners often rationally opt to avoid the cost of litigation by agreeing to settle claims that they believe to be without merit. Indeed, they will rationally decide to settle in cases where they realize that the probable cost of litigation will exceed the benefit of winning in court. 3, small businesses pay more to fight frivolous claims. While NFIB members are loath to write a check to settle what they perceive to be a frivolous claim, they express as much, if not more, frustration with the time spent defending against a lawsuit. In the end, of course, time is money to a small business owner. Once the suit is settled, however, the small business owner will pay with higher insurance premiums. Typically, it is the fact that the small business owner settled a case for any amount which drives up the insurance rates. It does not matter if the business owner was ultimately found liable. Many small business owners understand this dynamic and, as a result, will settle claims without notifying their insurance carrier. As such, small businesses annually pay over $35 billion out of pocket to settle these claims. 4, small businesses support common sense legal reform like H.R. 758. In crafting solutions here, we must acknowledge the practical circumstances of the small business owner threatened with protracted legal battle. Regardless of whether the plaintiff's claims are meritorious, the small business owner faces a difficult and often impossible dilemma: settle or risk everything. For this reason, Nfib has championed the Lawsuit Abuse Reduction Act, which focuses on tightening sanctions for frivolous lawsuits. This is the best reform to date to rein in the bottom feeders that target small business. Simply put, Nfib believes that this bill will help disincentivize both plaintiff and defense attorneys from taking brash and cavalier legal positions that result in frivolous and protracted litigation. We're hopeful through your deliberations you can strike the appropriate balance to protect those who are truly harmed and the many unreported victims of our nation's civil justice, America's small businesses. Thank you very much, and I look forward to answering any questions you might have.
Thank you, Ms. Bolito. And I now recognize our second witness, Mr. Peck. Please turn on your microphone, sir, before speaking.
Thank you, Mr. Chair. The 1983 rule was a failed experiment that caused some of the strongest judicial advocates of mandatory sanctions to reverse course and support its interment. Judge William Schwarzer, who also served as head of the Federal Judicial Center, originally supported the changes, but later saw that it was used for tactical purposes, multiplied proceedings, caused waste and delay, and increased tensions between the parties. It made the job of judges harder. The Judicial Conference, which opposes this legislation, has told this committee that the 1983 experiment spawned a cottage industry of tremendously wasteful satellite litigation that was all about strategic gamesmanship. It is a typical defense tactic to take a case away from the substance of the dispute, delay resolution, and outweigh the patience and resources of the injured party who is desperate to be compensated for his or her injuries. The mandatory nature of the 1983 version encouraged this. The discretionary nature of the current rule caused much of that churning to evaporate. Many lawsuits have multiple counts. Success on any one of them is success. The 1983 version of Rule 11 had the perverse effect of causing post hoc review of the counts that did not succeed, resulting in sanctions against the prevailing parties. A discretionary approach to sanctions allows a judge to separate the wheat from the chaff and only sanction when warranted. Sometimes a novel but difficult cause of action fails, but helps illuminate the merits of a sister cause of action pleaded together. As I stated in my written testimony, both Brown versus Board of Education and National Federation of Independent Businesses versus Sibelius, the Obamacare challenge of 2012, would likely have faced Rule 11 motions under the 1983 regime, but not under the current approach. The switch to the 1993 rule did not cause frivolous lawsuits to be filed. Judges have reported that little changed in filings, and in fact, they may have improved. Truly frivolous cases are still sanctioned. Judges have the same authority that this bill would require of them, and the requirement of making it mandatory sort of indicates that judges who really have very little patience for someone who wastes their time and is ready to invoke sanctions are basically not trusted to act with the discretion that the current rule has. They have that authority and they can award attorneys' fees and costs under the current regime. Sanctions are not always the best result. The distrust I mentioned is exasperated by the distrust of the process set out by the Rules Enabling Act. Rather than allow the courts to determine how to govern their own proceedings, H.R. 758 would directly amend Rule 11, cutting the judiciary out of the process altogether. It's not hard to imagine the protests that this body would air if the judiciary did the same as to how Congress conducted its own proceedings. Despite claims that civil rights cases in particular were not adversely affected once judges got the hang of the 1983 rule, the devastating impact on civil rights cases was palpable. The drop-off could be explained by fewer cases, only the slam dunks being filed, because of fear of sanctions. Even if advocates are right that judges eventually are going to be less harsh on civil rights cases, we have a new generation of judges now who would go through the same growing pains that the 1983 version had, thereby harming the constitutional right of access to the courts. The safe harbor language in H.R. 758 for civil rights and statutory-based claims does nothing to alleviate the problem. It merely repeats the same standard that applies to all cases regardless of how the lawsuit is filed. I suggest that today's Iqbal and Twombly standard for pleadings sufficiently protects against ill-considered lawsuits, making the comparisons between 1983 and 1993 academic. The plausibility standard basically supercharges the 1993 rule. I urge the committee to reject this proposal, which seeks a return to what Professor Stephen Burbank accurately described as an irresponsible experiment with court access. Its enactment will only expose Americans to more harmful products and misconduct by diminishing the opportunity to hold those responsible accountable. We would not know about the ignition switch defect in GM vehicles that took the lives if the 1983 rule, the rule that this bill would reestablish, was in effect, because the case was filed on a theory that there was a problem with the steering wheel. Compulsory discovery unearthed the ignition switch problem. In addition, this legislation would add to the cost of litigation, not lower it, as the number of cases affected, the vast number of cases affected will not be sanctionable. The double counting, wildly inaccurate figures this committee received that purport to reflect the cost of the tort system instead reflect the cost to maintain the insurance system plus the money that goes into it. It does not provide helpful or relevant information. Judges and attorneys, overwhelmingly, plaintiff and defense, support the rule as it's written today. I urge you not to alter it.
Well, thank you, Mr. Peck, and I would now recognize our third and final witness, Mr. Silverman. And sir, if you make sure that microphone's on.
Good morning, Mr. Chairman, Ranking Member Cohen, and members of the distinguished subcommittee. Thank you for the opportunity to present testimony today on behalf of the U.S. Chambers Institute for Legal Reform. The civil justice system is established to provide a remedy to a person who is wrongfully injured, to make that person whole. But what happens when the system is misused to harm someone, when it's transformed from righting a wrong to inflicting one? This happens when a person files a lawsuit to harass or extort someone. I'll sue you. It also happens when a lawyer takes a reckless or cavalier attitude, deciding to sue first, then research the law or investigate what actually occurred later. Now, victims of frivolous lawsuits have no meaningful remedy. They're not made whole for the very real losses that they incur as a result of a wrongful act. It's a problem that stems from the federal rules. The simple act of filing a short, plain statement of the claim, all that's needed to file a complaint, compels the person on the receiving end to respond. For an ordinary person or a small business, as Ms. Melito has shown, that means quickly hiring a lawyer and finding the money to pay the lawyer for his services. Lawyers are expensive. Dealing with a lawsuit means time away from work and lost income. It is stressful. Most of your constituents would be shocked to learn that if they're hit with a lawsuit that has no basis whatsoever in law or in fact, has near zero chance of recovering a penny of their expenses, even if they can prove to a judge that the case was baseless or brought in bad faith, even if the case is certain to be thrown out. This is how Rule 11 works in practice. You could be the judge of its fairness. Let's say John Small is served with a $100,000 lawsuit by a tourist who claims that while visiting D.C. 2 years earlier, he tripped and fell on the 5th and N Street Market. John has no recollection of this person or anyone else falling in his store. John now needs to hire an attorney to defend his family and his business from the lawsuit. The attorney quickly discovers that the plaintiff visited a store across town at 5th and N Northeast, not John's store in 5th and N Northwest. Nevertheless, the plaintiff's lawyer won't drop the claim. Let the court sort it out, he says. John's attorney tells his client that he should be able to get the case dismissed. Best case scenario, John's looking at about $12,000 in legal fees for the cost of the initial investigation, preparing an answer, preparing a motion to dismiss, and appearing at any status conferences and hearings. The only way to seek recovery of his expenses is to file a motion for sanctions. This seems worthwhile to John until he learns 3 facts about Federal Rule 11. First, his attorney must draft a motion for sanctions separate from the motion to dismiss and share it with the plaintiff's lawyer before he could file it. This is more lawyer time and money, maybe about $5,000. Once the plaintiff's attorney receives the motion, he can then choose to withdraw the lawsuit. A judge will never see the motion. John will not have his day in court to ask for reimbursement. The plaintiff's lawyer walks away without consequence. The motion and the money spent goes in the trash. Second, even if the plaintiff's attorney continues to pursue the lawsuit and the judge actually finds the case frivolous, the court may choose not to impose any sanction at all. Third, if the court does find the sanction appropriate, the rule prohibits the judge, we're talking about discretion here, the rule prohibits the judge from using sanctions for the purpose of reimbursing John's legal expenses. The court could simply require the plaintiff's lawyer to pay a small penalty to the court to deter future misconduct. That's what the rule says. The plaintiff's lawyer has asked for $10,000 to make the case go away, an amount just under the cost of litigation. John's attorney will give him three options. Option one, let's try to settle this case for $5,000 without incurring more costs for you, and you can move on with your life and your business. Option two, let's fight this lawsuit and be vindicated, but you'll have to pay at least $12,000 in unrecoverable legal fees to get it dismissed. Third, let's seek dismissal and sanctions. You'll incur closer to $20,000 in legal fees, but you'll have a very small chance of recovering some of them. Individuals, business owners, and their insurers routinely face this choice. Most settle and cut their losses. Some fight for dismissal on principle. Very few seek sanctions today. What choice would your constituents make? LARA restores a remedy for victims of lawsuit abuse and ensures that judges have an opportunity to consider whether claims and defenses are frivolous. Thank you.
Thank you all for your testimony. We will now proceed under the 5-minute rule with questions, and I will begin by recognizing myself for 5 minutes. Ms. Melita, we hear anecdotal stories of small businesses being forced to settle lawsuits for $5,000 or $10,000, not because there's any merit to the plaintiff's case, but because it's simply cheaper to settle than to defend against a lawsuit. In your experience, in addition to your testimony, can you elaborate? Does this occur? And if so, will the Lawsuit Abuse Reduction Act change this reality for at least some cases brought in or removed to federal court?
Thank you for that question, Mr. Chairman. And yes, absolutely. The passage of the bill would benefit small business owners in many ways. And I want to go back to actually your word in your opening statement about the deterrent effect of the bill. And that is really so important. The business owners whom I represent and speak with on a near daily basis don't want to be in court, period. They don't want to be threatened with lawsuit, but they don't want to be in court, period. And the simplicity of this bill is just that it's going to force attorneys, again, both plaintiff attorneys and defense attorneys, to do their homework. And as you said, before they file a paper in court, ensure that it's based on facts and law. And I think it will really do a lot to deter these kind of frivolous claims that might lead to a lawsuit and deter attorneys from, making these settlement demands, because knowing that they can't, file a suit afterwards, a frivolous claim afterwards. So I think it will have a very big impact on small businesses.
Well, thank you. Mr. Silverman, recently, prominent consumer advocate Ralph Nader described the Lawsuit Abuse Reduction Act as, quote, even-handed, in that it would apply sanctions to both plaintiffs and defendants when they make frivolous claims or defenses. Can you help me understand why a gentleman with the perspective of Ralph Nader would describe this bill as, quote, even-handed?
Well, Mr. Chairman, I think that even very knowledgeable people sometimes have the misconception that Rule 11 only applies to frivolous claims brought by plaintiffs. But Rule 11 is actually an extremely balanced rule. If you look at its text, it applies to victims of frivolous litigation on both sides. It applies to any pleading, written motion, or other paper, whether it's filed by a plaintiff or a defendant. And a plaintiff's factual contentions must have evidentiary support, just as a defendant's claims of denials of facts must be based on evidence. Claims and defenses must be warranted by existing law. Plaintiffs can't file lawsuits to harass others, just as defendants cannot use delay tactics for purposes of litigation. That's all covered by Rule 11. And I think if you look at the case law between 1983 and 1993, you'll see many cases, many Rule 11 sanctions brought against defendants as well.
Well, thank you, sir. Let me just follow up. One of the concerns raised by mandatory sanctions is that they will potentially chill plaintiffs from being able to bring legitimate cases. But isn't the bar fairly high in terms of what the courts would consider a frivolous claim? I mean, a frivolous claim isn't frivolous simply because the plaintiff loses. And can you elaborate on that?
Thank you, Mr. Chairman. Yes, that's correct. Plaintiffs with legitimate claims really should have no concern about LARA. Rule 11 sets a very high standard for a violation. It's not simply losing on a motion to dismiss. There has to be either an improper purpose shown, harassment or delay. There has to be no basis in fact, or no basis even after a legitimate chance for discovery, and no basis in the law or a reasonable argument for a change in the law. And judges have significant discretion under the current rule and under LARA to decide whether those standards apply. Judges are lawyers too, and they are very reluctant to impose sanctions on a party's lawyer for not meeting these standards. They take a very hard look and take their responsibility very seriously.
Well, thank you, and I will now yield 5 minutes to Mr. Cohen for questions.
Thank you, Mr. Chair. First, I asked each of you to consider telling me when there had been another incident where the Congress had initiated a law, a rule, without the courts requesting it. Ms. Melito, can you give me an example?
I cannot, and I'd be happy to.
Mr. Silverman, can you give me an example?
Well, Mr. Cohen, there are examples.
What are they?
Of situations where Congress has intervened when they've found that fee shifting is supported by public policy, and those are not in the rules themselves, but they're in a series of statutes. So the answer is no.
The answer is no. You know of no rule that has been passed this way.
No rule.
Mr. Peck.
The only time that Congress has ever suggested any kind of procedural thing is when it's intermingled with a new substantive cause of action. No general rules.
Thank you, sir. Ms. Melito, in your statement, you said, quote unquote, small-time lawyers bring these cases. As a self-practicing attorney, and I know lots of them, how do you define small-time lawyer?
I'm talking about the lawyers that are printing out form complaints and maybe only changing the business name. The lawyers that are not doing their homework before they file a paper
I would
in
submit
court.
to you, I don't know what you meant, but small-time lawyer I find offensive to many lawyers who have small practices, who are small-time business people. They are small business people, and they work hard, and they work by the rules, and they bring cases, and they don't boilerplate. I would submit that you should try to find a better term than small-time lawyers. My
intent was not to offend any attorneys. We certainly have many members at NFIB who are attorneys, and
Thank
in fact,
you,
members
Ms.
at
Melito.
NFIB
Thank
who
you very much.
practice
Mr.
plaintiff
Peck,
side.
are anybody else here, are y'all familiar with these examples that the chair gave about an ironing board warning that you shouldn't iron while your clothes are on, and a fishing lure that you shouldn't ingest it, or a wheelbarrow shouldn't be on the hospital? Are those did the courts order that because of a small-time lawyer or some other lawyer that went into court and got some kind of a judgment, or is that just a manufacturer being overboard?
I am not aware of any case where liability was assessed for the failure to provide a warning of that nature. What we have found in studies that have been published in various law reviews is that often when these warnings appear, they're the result of in-house counsel making a suggestion to their company, saying, you know, let's do something like this so that there's no chance anyone can get it wrong. This is, of course, over-lawyering.
Mr. Silverman, the American Bar Association and the Federal Judicial Conference both oppose LARA. Neither are known to be great apologists for trial lawyers or small-time lawyers. In the 2005 Federal Judicial Center, more than 80% of judges agreed that Rule 11 is just right in its current form. Only 5% favored the 83 revision. Why should Congress not defer to the judgment of the judiciary?
Mr. Cohen, Rule 11 is different, and LARA is different than other federal rules. It, unlike other rules that deal with changing the number of days for filing a complaint or an answer, how many interrogatories you can have, time limits, etc. It's not a purely procedural rule. This is a rule that deals with providing rights and remedies of people. It's something that Congress does.
I know what Rule 11 is, but the courts are all against it. And the Judicial Conference against it, the Bar Association is against it. Why should we go against the expert logic and come up with something
They
new?
weren't against it when the rule was in effect. If you look back, there was a 1990 study where 95% of judges said, and this was a survey of all of the judges, and 75% actually responded, 95% that it said it did not impede development of the law, 3/4 said that the benefit in deterring frivolous lawsuits and compensating those who are harmed outweighed the use of judicial time to decide the motions, and 4 out of 5 said it had a positive effect on litigation. Now, there are other studies, which others have cited here, and those are later. They're small.
And the Judicial Conference 3 years later recommended a change.
They did recommend the change.
But they don't recommend a change now. But you're submitting we should go against the Judicial Conference now?
The Judicial Conference knows a lot about the procedures and the mechanics of the courts, but this is an area that involves rights and remedies, and it's a good place.
This is an area where we should forget the courts and appeal to the thoughts of the public that think all judges are bad, that all government is bad, and we should kill the judges. This is what you're saying, that we shouldn't listen to the judges on this. We should listen to the public that says the judges are bad, the lawyers go first, and all that.
That's
Miss Laura, let me ask you this.
Just a moment. Mr. Silverman, you didn't say anything about killing the judges, did you?
I certainly did
All right,
not
I just
say.
wanted to make sure.
Shakespeare did that.
In fact, I'd like to
lawyers.
get more discretion than they have today to look at these cases.
Ms. Melito, the small business said this is a very minor problem they have. They rated it in the lower, in surveys, the lower 3 or 4 out of 75 problems that they had with business. Cost and frequency of lawsuits, threatened lawsuits, was 71st out of a possible 71 in a survey taken in 2012 by the Nfib. Why is it such an important issue when it's 71st out of 75?
I'm going to start off with this quote Mr. Silverman used in his testimony. Judge Learnedhand said, "I should dread a lawsuit beyond almost anything short of sickness and death. If today you were told you had a terminal illness, I bet it would become your #1 problem and priority." And as with a lawsuit, most of the members I speak with don't even think of it until it's staring them in the face.
Well, Ms. Melito, I don't have cancer right now, but I'm concerned about it, and I'm frightened of it in the prospect of the future and all illness. And I think if it was a major thing for small business, because it could happen, it would rank higher than 71st out of 75th, and I yield back the balance of my time.
And I thank the gentleman. I now recognize Mr. Nadler, the gentleman from New York, for 5 minutes.
I thank you. Mr. Peck, the committee report on Lara from the last Congress cited one of the points against Lara is that it makes sanctionable, arguably, the use of novel legal theories, which could be considered frivolous. The committee report, and that implicates in particular civil rights lawsuits. The committee report from last Congress cited the case of Nikki Youngblood, who, quote, filed suit after her picture was left out of the school yearbook when she refused to wear a feminine drape instead of a shirt and tie as she wished, unquote, as an example of a frivolous claim. To date, there are 14 states with laws that address discrimination against students based on gender identity. While the majority clearly considered Nikki to be an example of a frivolous lawsuit, might this be an example of a valid civil rights claim worthy of judicial consideration? Doesn't this highlight the potential chilling effect on civil rights claims? And by the same token, might the claim in Loving versus Virginia on mixed race marriages, or the claims, in fact, when the same-sex marriage case was brought before the Supreme Court, I forget how many decades ago, it was dismissed as absurd, and now the Supreme Court has ruled differently. Might all of these things be barred and sanctionable under this bill?
It is entirely possible that they would be. We often get fractured versions of the facts that underlie cases when they're used as examples like this. But let me give you 2 examples from my own experience, 2 cases that I'm currently working on. One, I'm representing the city of Miami on a Fair Housing Act case that they brought against various banks. Los Angeles has also brought similar cases. In Los Angeles, the cases in federal court were the ruling was against the motion to dismiss, and the cases are going to trial. In Miami, the judge found a precedent that not even the banks had cited and said that there is no basis for the city to have standing here and that this was a frivolous argument. If this rule was in effect, the city of Miami would have been sanctioned for bringing this suit, which is approved by a U.S. Supreme Court case which upheld the standing of municipalities to bring these kinds of lawsuits. We're now in the 11th Circuit on that case. A second case that I want to just bring, on Saturday I received a petition for certiorari. Actually, it was 2 petitions for certiorari filed by Walmart out of a Pennsylvania case. These are cases in which Walmart lost wage and hour class actions. But they're not sure whether they're supposed to be appealing from the Pennsylvania Supreme Court's decision or the Pennsylvania Superior Court. So they filed 2 petitions for certiorari and asked the court to sort out what they should do in an abundance of caution. If Lauer were in effect, it would seem mandatory that one of those petitions was frivolous.
Thank you. Let me just ask before I switch to a different topic. Such lawsuits as Citizens United versus the Federal Election Commission, District of Columbia versus Heller on the Second Amendment, Commonwealth of Virginia versus Sebelius that went to the Supreme Court on the Affordable Care Act. Could not all these cases have been considered frivolous and sanctionable given the novel legal theories underlying them? All of these cases, of course, well, go ahead.
Yes, you know, in each of those instances, people made claims that the theory behind them was ridiculous, was frivolous, and as a result, even in the Obamacare case, you had law professors urging the government to seek sanctions. If this mandatory rule were in effect, they would seek sanctions, and we would have seen hearings on the sanctions rather than
Thank you. And talking about hearings on the sanctions, during the decade that the '83 version of Rule 11 was in effect, which this bill would seek to reinstate, at least a quarter of all cases in the federal civil docket were burdened by Rule 11 proceedings that did not result in sanctions. Almost every case had 2 cases, a sanctions case as well as the underlying case. Based on our experience with the '83 version of the rule, and for that matter with the '93 revision, do you think that this bill, if enacted, God forbid, would lead to a lot more rather than less litigation?
It's not only my judgment, but it is the judgment of the Judicial Conference.
So the Judicial Conference judged that this would be increasing litigation, increasing court costs for all involved, and on what, well, let me ask Mr. Silverman, on what basis are they wrong, and how are we making the whole system cheaper by increasing litigation so that every lawsuit, or a large majority of lawsuits have Rule 11 sanctions appended, hearings and litigation appended to them?
Mr. Nadler, thank you. It's a pleasure to be before you today as a Brooklyn native, so I want to thank you for your service. Satellite litigation, there was a lot of concern about that. I understand those concerns. And some of it...
But there was a reality to it, not just a concern.
Some of it stemmed from the change in the rule from in 1983. It was very different before that. But there's a couple of responses, a couple of factors I'd ask you to consider. First, I think we have to look at why is a Rule 11 motion different than some other types of motions that the courts decide every day. If you look at any federal court docket, there's going to be motions for summary judgment, for dismissal, for expert testimony issues, for venue, jurisdiction, what have you. Judges decide those motions in the routine course of business, and if they find that it lacks merit, as with the Rule 11 motion, all they have to say is one word, denied, and they move on with it. I think we also should consider the alternatives to allowing the motion, which is a system where a person who believes they were harmed by a frivolous lawsuit or defense has no way of bringing that before the judge. In terms of the satellite litigation issue and the numbers I've seen, I know in Mr. Peck's testimony, and I've seen cited other places, that there were something like 7,000 sanctions motions in the period where this stronger rule was in effect. But you have to look at that in context. That was over a 10-year period. There's almost 700 federal judges.
My time has expired. I want to say one sentence in response to what you said, and that is the reason it's different is that a motion to dismiss or a motion for summary judgment is on the same underlying question, whereas a Rule 11 proceeding is an entirely different question than the underlying question. So it's a whole different fact consideration. I yield back. Thank you.
And I would certainly defer to the gentleman's expertise in novel legal authority, novel legal theories. And I would now recognize the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. Mr. Peck, can we just back up for a second? When the Rules Advisory Committee amended Rule 11 in 1993, it gave courts discretion to impose sanctions and noted that the purpose of the sanctions was to deter bad conduct, not to reward the other party. Why did the Rules Advisory Committee, give courts this discretion, which this bill would take away? And why has the purpose of sanctions deterrence why was the purpose deterrence rather than compensation?
Well, first of all, the courts do not want frivolous filings. And so that's the reason for the deterrence factor. And what the committee did was say, here, the filing of these motions are something that we will determine, but not every motion and every filing is necessarily of the same nature. They don't have the same qualities to it. They may be better remedied by instruction to the jury that they're allowed to infer something because of this filing. And that often can be more devastating to a case than not. So there's flexibility because different sanctions are appropriate for different types of filings. But second of all, the courts retain inherent power to shift costs if they want to. So that didn't have to be in the rules, and courts continue to use that power.
And then looking ahead, Mr. Silverman, you had cited a study. You had cited a survey to support the 1983 version, a survey from 1991. But obviously, at this point, we acknowledge that the Judicial Conference opposes restoring mandatory Rule 11 sanctions. Federal judges overwhelmingly support Rule 11 as it currently exists. Your study was from 1991, which you used to show that the old system worked. But in 2005, the Judicial Center issued a report entitled "Report of a Survey of U.S. District Judges' Experiences and Views Concerning Rule 11." More than 80% of the judges said that Rule 11 is needed as is just right and is just right as it now stands. 87% of the judges who responded prefer the current version of Rule 11, and just 5% preferred the version of Rule 11 that existed between 1983 and 1993, and only 4% preferred the version of Rule 11 as proposed in the Lawsuit Abuse Reduction Act. 91% opposed a requirement that sanctions be imposed for every Rule 11 violation, and 84% disagree with the proposition that an award for attorney's fees should be mandatory for every violation. 85% believe that the amount of groundless civil litigation has not grown since the promulgation of the 93 rule. And before getting to the question, Mr. Chairman, I ask for unanimous consent to submit the 2005 Federal Judicial Center report in the record.
Without objection.
I appreciate that. So other than your statement before that this is something you would like Congress to address, why should we consider the 1991 results relevant when in 2005, with a lot of experience, the judges who actually deal with Rule 11 have determined that it works the way it is now?
I appreciate your question. I think it's important to look at the 1991 survey, not just because it was the most extensive of the surveys that have been conducted, but because these were judges who actually had several years' experience with the former rule. The 2005 survey, half of those judges that were included never actually were appointed after the new rule, the current rule, was in effect, so they never saw how the old rule happened.
So the overwhelming majority of judges, 87% who prefer the current version, since some of them had only become judges since the rule changed, their opinions don't matter on this.
There may be one area where actually there are two areas where I think all the surveys are consistent. I think they're consistent, and even if you look at the 2005 and the 95 and the older one I cited, all the judges say that a compensatory structure, compensatory reason.
I'm sorry, I'm running out of time, but I want to be clear. I mean, I'm not looking for consistency in the surveys. I'm trying to understand why we should discard the overwhelming support for the system the way it is now and moving forward. But let me just finish with Mr. Peck. Mr. Peck, you had said, you had raised some concerns about what this change would do to civil rights cases, and you mentioned Brown versus the Board of Education. Could you elaborate a bit on how that case in particular might have been impacted if this change had been in place then?
Well, as you know, the issue was whether separate was not really equal. And the evidence that was produced in the case showed that the Topeka, Kansas schools were actually substantially equal in facility and in quality of teachers, in the curriculum, in what they provided to both black and white children. Robert Carter, who served as a federal district court judge in New York for many years, was part of that litigation team, and it was his judgment that if the 1983 version of it was in effect, Brown would have received sanctions. They would have been fearful of bringing the case and may have waited another 10 years before it happened.
Right. And, Mr. Chairman, this country would look very different than it does today. I thank you, and I yield back.
I thank the gentleman, and I thank all of you. And this would conclude today's hearing. And without objection, all members will have 5 legislative days to submit additional written materials and written questions for the witnesses or additional materials for the record. And we would again thank the witnesses and the members and the audience. And with that, this hearing is adjourned.